I don't want to hear it. I don't have anything to do with that. Listen.
Yes, Judge. How you doing? How are you this morning?
Not too bad. We'll see how this one goes. Your name, Detective?
Detective Sergeant Mark Driscoll with the Trent Police.
Yeah, call him. Your name, ma'am? Ma'am?
Oh, Teresa Bubba?
Your Honor,
Your appearance.
for the record, just 30720. Thanks.
I'd like to call you and the prosecutor in.
Prosecutors and what Judge House.
I could start off perhaps without the prosecutor, if I may.
Yeah.
Your Honor, I know Miss Riddle from some previous representation. She had a felony in front of this court for a preliminary exam, got found over. And after that preliminary exam, I was assigned a representative. She discharged me. There was no problems with that. It happens. And she went through a number of attorneys after that. And today, lo and behold, I saw her here, and then I was going to represent her. And she informed me that she'd rather have another counsel.
Mr. Bologna, your name?
Anthony Blank at the City of Trent, Your Honor.
Before this hearing even begins, the tension in the courtroom is already obvious. The judge immediately shuts down an argument with the words, "I don't want to hear it." That's usually a sign that something unusual has already happened before the camera started rolling. When a judge opens with that level of frustration, it tells us this case might not follow a normal courtroom path.
All right.
So the big question is,
I don't know what to
exactly
say on
happened
this.
behind
You
the
don't get to
scenes
pick your
trigger
own
such a
lawyer. What did
reaction?
Mr. Schloff do wrong?
No, it's just that he did not represent the
Well, I don't know what that means. I mean, I don't know what that means. You got to be more specific. He's a good lawyer. Turn that microphone toward her, will you please?
He just didn't, I wanted him to be aware of certain things and handle things in a certain way. And I just had to handle it without.
On the other case? Yes?
Felony case.
Has he done anything wrong on this case?
Well, I mean, it's still, he's got that previous record.
What record?
Well.
You don't have a felony record, do you? Or a misdemeanor record? What record?
Just, I mean, I didn't like how the previous,
Ms. Riddle?
hearing.
Can I, I'm just going to have a candid conversation. Mr. Bologna, your name?
Anthony Blank, City of Trent.
Detective Driscoll, I got a disturbing call the other night about accusations that Ms. Riddle has levied against me.
This moment highlights an important legal reality. Many people misunderstand defendants do not always get unlimited freedom to choose or change their lawyers, especially when the lawyer is court-appointed. Judges generally require a strong and specific reason before removing an attorney from a case. Simply saying you prefer someone else usually isn't enough. That's why the judge is pressing for details here, trying to determine whether
Yes, Your Honor.
there is a
If you
legitimate
need,
legal
for the record,
issue
I can
or
send
simply
you a copy
dissatisfaction
of,
from
I
the
need it.
defendant.
I know.
Yeah,
I'll say it. I don't even know the lady. She was accusing me of assaulting her, and she was accusing me and another judge of conspiring to hire a hitman to have her killed. I can still handle this case fairly. I think there's other issues going on. I'm ordering a competency exam on this, and I'm going to order it now, and I'm going to continue the bond, and we will have a competency exam, and that's it. I just don't. I was.
Now the situation takes a dramatic turn. The judge reveals that the defendant accused him of assault, and even of conspiring with another judge to hire a hitman. These are extremely serious claims. However, statements like this can raise another critical legal question: whether the defendant is mentally competent to stand trial. When a judge believes someone may not fully understand reality or the legal proceedings, the court can order a competency evaluation to determine if they are capable
accusations that are false levied
participating
against
in
me
their
in
own
32
defense.
years, but that's ridiculous. So, ma'am,
It was a tribute for the newspaper.
You shouldn't get into the details at all.
competency exam is ordered. I'm going to keep you on the case. You don't have the right to hire and fire court-appointed lawyers. If you're not happy with Mr. Schloff, you're going to have to be more specific. I'm not prepared to discharge him now. We'll see how the competency results come back. And we will go from there. And competency exam ordered. We'll set this for arraignment and pretrial. I'm guessing that they're taking at least 2 months, right? So why don't we set this up for sometime in the middle of April? And
It'll be on a Thursday as well.
yes, and I'm not going to remove Mr. Schloff. You haven't given me any reason. I've been around Mr. Ma'am. I've been around Mr. Schloff enough in my career. I have a great deal of respect for him. I would find it hard to believe that he did anything wrong. And when we come back, if you still want him discharged, you're going to have to be a lot more specific about what he has done wrong in this case, okay? But I'm ordering a competency exam. You have to go down and get evaluated, okay? I think this is for your own good. We'll set it for a, ma'am.
You're gonna send me, I've already had, call our,
I can't hear you, ma'am. You got to talk into the microphone nice and loud.
I've already, worked with what I was trying to do was file charges with the Trenton Police Chief, and he has refused for the last 2 years to file any charges or complaints. And then when they arrested me, and that chief spit.
All right. I don't want to hear it.
I'm gonna file.
What's striking here is how the judge handles these accusations despite being personally targeted. Calmly explains that he can still manage the case fairly. Judicial ethics require judges to remain neutral, even when emotions are high. Instead of responding defensively, focuses on the procedural solution, ordering a competency exam to ensure that the legal process remains fair and balanced for everyone involved.
Listen. I'm going to send you for a competency exam. I think we can help you. Ma'am, do not argue with me, please. That's what I'm ordering. We're going to give her a review hearing date in the middle of April, and we will go from there.
She received a letter from
The Forensic Center. So we need to make sure, do you live at 1795, apartment 119?
My address is general delivery because
Ma'am, I can't tell the Forensic Center to send it to general delivery and have it gift to you. Tell
Judge,
me
if I can interrupt, she does not reside at 1795 any longer. She was evicted from that residence. I know she's moved from hotel to motel over the last several months.
What's her P.O. box?
Ms. Riddle, if you can provide that.
What is it? I hope you go and look at it every day, because don't come in here when you don't show up for the exam and tell me I never got it. I didn't check my P.O. box. I don't know what else to tell you. You got what I'm saying?
Yeah, I'm sure.
Yeah, Trenton Post
I
Office.
just wanted to make sure.
So that's where we're going to send the mail. We're going to set a review hearing in the middle of April. When will that be, Heather or Amy?
Judge, we could do either April 9th or April 23rd.
Let's set it for April 9th at 9:30 in the morning. You go down the hall, get your notice, but you have to show up for the forensic. I want you to listen to me very carefully. Sometimes things go awry in our life. We have problems.
At this point, the judge draws a firm boundary. Courtrooms operate on strict rules, and when a judge decides a topic is no longer relevant, continuing to argue can disrupt the entire proceeding. The judge is no longer debating the claims he is enforcing. Courtroom order. His focus shifts to moving the case forward through the proper legal channels, which in this case means arranging the competency evaluation and scheduling.
I think you'll find out
hearing.
this will work better. Detective, if there's something else to add, I'll be glad to listen. I see no reason for me to recuse myself at this point. I think it's just...
I asked you to recuse when I was in authority before, and,
You asked me to recuse myself?
Can you say before, during the pendency of this charge?
I don't think she's ever been...
it was when that girl, that she had 3 vicious, unleashed dogs
Ma'am,
that attacked me.
ma'am,
And I asked to recuse.
Well, okay. I have to have a basis for it. I have to either be biased for you or against you. And ma'am, please don't interrupt me. You have a tendency to interrupt people. There's nothing here that makes me biased for you or against you. Okay? Your allegation's so ridiculous, it's laughable. I'm not getting into this anymore. Go down the hall, get your review hearing date. I'll address the issue with Mr. Schloff when you come back. You got to show up for your examination, and we'll let it play out. That's it. Have a good day.
Can I request the FOIA in the court hearing?
Request what?
The FOIA from that court hearing,
What court hearing?
the one where I asked you to recuse yourself.
Ma'am, I don't even know when it was. I don't remember. Well, then you request it, you pay for it, and we'll be glad to type the transcript up. I don't care if you did or not. I'm not biased for you. I'm not biased against you. This is the way I do my job every single day. I'm not going to hear it anymore. Back away from the podium, go to the exam, go down the hall, get your notice, and I'll address all these issues then.
In this final stretch of the hearing, the judge's tone becomes more reflective. He acknowledges that sometimes life can become complicated and overwhelming. His